Okay, Aditya, so let's start with the session. Just give me your brief introduction without disclosing your name.
So I am from Shimla. I am 26 years old. I have done my graduation from DAV College, Chandigarh. Thereafter, I have done my LLB from HPU University. And thereafter, I have started my practice. And while doing practice, I have done my LLM from Bhara University.
So why you want to be an ADA? You are having your own chamber, like the father's chamber is there. You probably in the next few years you will be earning good also, right? And you might
Mhm.
be having certain independent cases also. So why you want to come into the government service?
So because there is definitely a purpose, that is the job security that is always there, that will always remain there. Even though and then also it is my father has only done something, and my contribution should be there. I have to do something of my own. And I believe that there has also be a certain scope of expansion. Expansion is very necessary.
So
Yes, so
what
that is
I
my
believe that like your father is already 60 years of age and he's an advocate, so you
yes, sir.
must participate with him. It is also something by which you can contribute to the society.
Yes, sir. But even if I get into the ADS, sir, that is the benefits that I would be still be in practice. I would still be in practice. I would still be in touch. But then the whole, there will be a certain variety of cases I will get to deal with. I will get to represent the state.
Uh, ठीक so as you mentioned you have seen the civil litigation तो मुझे एक बात
Yes,
बताइए
sir.
आदित्य suppose suit is to be filed against a government,
Yes, sir.
right? So what is the process of that?
So firstly, a prior notice of 2 months has to be given under Section 80. That is the
Hmm.
general procedure. You can bypass that by filing a subsequent application, Order 80 Rule 2 में. But only the but any order passed shall not take effect, but only if it will take effect after the government has been given notice.
नोटिस किसको जाएगा, सरकार में किसको जाएगा नोटिस?
Sir, if supposingly the state government and secretary or
हम्म।
commissioner को जाता commissioner
आपने कोई कोई
state
किया
government.
ऐसा, कोई केस ऐसा देखा है जिसमें सरकार के अगेंस्ट केस किया हो?
Yes, sir.
हाँ, कुछ बताइए कौन सा केस है, किसके बारे में?
So it is titled as Ramkrishan versus Tarachand. It is
हम्म।
basically pertains to the changes in revenue entry. It was earlier, it was before that, it was pending before the Tehsildar, and because there was a question of title, we went into the civil court, and because there were also involvement of some state officials, so they were also made the party to that suit.
ओके, ठीक। सो एज यू वांट टू बी एन एडीए, तो मुझे एक बात बताइए आदित्य, एडीए का कोर्ट में क्या
Yes,
क्या
sir.
रिस्पॉन्सिबिलिटीज?
So in the supposingly if the post is ADA, so I will be if I am an ADA, my responsibility will be conducting trial in the court of judicial magistrate, chief judicial magistrate, and other magistrates. So I have to lead the whole trial.
हम्म।
My responsibility is to conduct a fair trial, lead all the evidences, uh, show be all the necessary details to be furnished to the court, and help the court in achieving it a suitable decision.
मान लीजिए पुलिस वालों ने एक चार्जशीट फाइल करनी है कोर्ट में,
Yes, sir.
तो हाउ द पुलिस ऑफिसर विल फाइल दैट चार्जशीट बिफोर द कोर्ट?
So firstly, it will come to the notice of the district attorney. He will certify whether the tribal case has been made out or not. Then it will go to the court, sir.
कैन यू टेल मी, अच्छा हिमाचल में as you had
Yes,
filled this particular exam, so there is the eligibility criteria for minimum 2 years of practice.
yes, sir.
Do in the criminal procedure code or in the BNSS for the post of assistant public prosecutor, we are having any minimum eligibility criteria?
So this is section number. 24 and 21. No, sir, I don't think so. In my limited knowledge, sir, I have not read it.
Hmm. My second question to you is, Aditya,
Yes,
that
sir.
suppose, let's suppose you got appointed. Because of
Yes, sir.
certain reasons, you take a casual leave. So who will conduct prosecution on your behalf?
So basically, the DA's office are having a number of ADAs. So
Hmm.
anybody in my place would go and conduct the proceedings. That occurs, sir.
Okay. Okay. Can a police officer conduct a prosecution himself?
Uh, sir, if he's not involved in the investigation, then he can do, and he has to be a rank of inspector, sir, or above, sir.
Let's suppose a police officer was directed to execute a warrant. मैजिस्ट्रेट ने वारंट जारी किया और वो वारंट एग्जीक्यूट करने के लिए पुलिस ऑफिसर को दिया गया बट दैट पर्सन इज नॉट गेटिंग अरेस्टेड
Yes,
सो
sir.
व्हाट विल बी द नेक्स्ट स्टेप द पुलिस ऑफिसर विल टेक अप एंड व्हाट विल बी द रोल ऑफ द पब्लिक प्रोसिक्यूटर एट दैट टाइम
If a person is not getting arrested,
यस
uh, so firstly we have to identify why he's not getting arrested. If he's absconding what is the reason of his non getting arrested?
हाँ लेट्स सपोज ही हैड
Supposingly, if
absconded
his
then
says property can be attached, a proclamation can be issued against him to appear at a certain date. If it
okay
still does not come, the property can be attached.
so you have dealt with the cases of section 138 of negotiable instrument act तो क्या वहां पे भी पीओ डिक्लेयर हो जाते
Yes,
हैं
sir. PO, yes, sir. They are declared PO.
कितनी मैक्सिमम कितनी सजा है नेगोशिएबल इंस्ट्रूमेंट एक्ट के अंदर
Sir, twice the amount of a check amount and 2 years imprisonment.
समरी ट्रायल चला सकते हैं मैजिस्ट्रेट्स
Summary trial, yes, sir.
let's suppose magistrate has taken up the summary trial. So what the maximum punishment he can give in such a case?
In terms, sir, it was, I'm not sure, but it was around 6 months, sir. Sorry, I'm not sure about it. It was 6 months, as per my limited knowledge.
Okay. Let's suppose you got selected today. Now you are appointed as a public prosecutor. You are there in the court. So just tell me what are the stages of trial before the court of magistrate in a
Yes.
warrant case?
So basically, after the final report and everything has come to the court, the accused is there, depending upon whether bail is granted or not. Then there comes the checking of copy case. The copy of whole the challan is given to the accused or his pleader, whatever the case may be. Then on the basis of it, the copies are checked whether there is any deficiency or not. Then there is a framing of charges, or it is also stated to be consideration of charges.
Hmm.
वहां पे the charges are framed, the narration is done, what the accused is being charged of under what section and whatever he has done. Then comes the PW stage where the prosecution witnesses are examined. Then there's the stage of statement of the accused. Earlier it used to be 313 CRPC, sorry sir, 313 CRPC. Then comes this stage of the PWs where the accused can examine his own witness in his favor. Then there comes the stage of argument, and then there is judgment.
Okay, let's suppose the court had framed the charges.
Yes, sir.
Subsequently, there are certain facts which were not in the knowledge of the court earlier, or there is certain change in the facts.
Yes, sir.
You are a public prosecutor in that matter.
Yes, sir.
So, under which provision you will make application for making an alteration in the charge?
So onwards, 216 CRPC to 224 is a provision that prior to the judgment, the charges can be again framed if it does
So
not result into.
there is only one provision for that.
Yes, sir. Sorry, sir, I'm not able to recall it. I have read it, but I'm not able to recall it.
216 की एप्लीकेशन लगाएंगे ना,
Yeah.
216 सीआरपीसी की एप्लीकेशन लगाएंगे। सो चार्जेस कभी भी ऑल्टर हो सकते हैं।
So prior to the judgment, they can be altered. Only
prior to
that
the
is the
judgment, once the
yes.
judgment is pronounced, thereafter it cannot be
No,
appellate proceedings में।
appellate proceedings may generally I have not seen it, but remand back करके वो then there is a possibility.
क्रिमिनल केसेस रिमांड बैक हो जाते हैं।
No, sir, I have not seen it.
सिविल केसेस में है रिमांड बैक का ऑप्शन।
Yes, sir.
कैन यू टेल मी हाउ दिस रिमांडिंग इज डन।
So, can I take a help of illustration
यस,
just to
यस, यस।
so supposingly in the appellate court it is found that a mandatory an important issue was not framed.
हम्म।
So in that cases the appellate court can remand back to the trial court and to for framing the issues and then deciding it again.
Do advocate general is a part of a department of prosecution?
No, sir, but because he's the head of the general advocates, he's the general head of advocates, he is considered to be the at the hierarchy, at the topmost hierarchy.
My next question to you is, Aditya, that being a prosecutor, you are having a
Yes,
lot of responsibilities. So there is a concept related to withdrawal of the prosecution.
yes, yes, sir.
So can you please tell me, like, what is the process for making a withdrawal of the prosecution, or in what scenario the prosecution will be withdrawn?
Sir, if after the supposing before framing of charges, if there appears that no particular offense has been committed, or
Hmm.
if it is the requirement of the justice that this case should not go forward, then by moving an application before the court, you can always withdraw it, and the learned judge will consider it, and it will result into the discharge.
So can you make the withdrawal application by your own discretion, or the government will give a direction on that?
Sir, definitely government will give. I can give my recommendations to the government, and government may consider it and then revert back to me, and they can what they will do. I will have to do whatever they ask. Sir.
Okay. So just tell me, what is meant by discovery statement?
So any fact which lead to discovery of any relevant fact or it connected with fact in issue by an accused,
Hmm.
or so that is called a discovery statement.
ये पुलिस वालों को कन्फेशन दिया एक एक्यूज ने,
Yes, sir.
और इट इज विदाउट एनी फियर, विदाउट एनी इंड्यूसमेंट,
Yes,
तो
sir.
क्या वो रेलिवेंट हो जाएगा?
No, sir, because an confession given to the police officer, unless it is without in the immediate presence of the magistrate, it is not valid, sir.
Hmm. तो इन द इमीडिएट प्रेजेंस ऑफ द मैजिस्ट्रेट जो है, ये कौन सा कन्फेशन है?
It is a extrajudicial confession, sir.
एक्स्ट्रा जुडिशियल है या जुडिशियल कन्फेशन?
Sorry, sir, judicial confession. Sorry, sir.
So what is the process of recording judicial confession?
So the accused has to be in the presence of the magistrate, sir, and he has to depose his statement in the presence of magistrate.
Hmm.
Then this statement is recorded. It is read over to him. It is signed by him. That forms the confession, sir.
Okay. तो आप कल को लेट सपोज प्रोसिक्यूटर बन गए,
Yes,
तो
sir.
विटनेसेस की गवाहियां रिकॉर्ड होगी,
Yes, sir.
राइट? तो जब आप ऑपोजिट पार्टी के विटनेसेस को क्रॉस करोगे तो किन चीजों का खास ध्यान रखोगे?
Opposite party की sir, generally is the rule of admissibility and mode of proof.
हम्म।
Uh, ये primary consideration होते हैं, because an objection may be raised from the opposite side, that what is the mode of proof and what is how it is admissible.
हम्म।
So, and pertaining and limiting my cross examination to the fact in issue, that is the most relevant part.
सो आप तो क्रॉस के समय तो कोई भी सवाल पूछ सकते हैं। इट इज नॉट रिक्वायर्ड टू बी रिस्ट्रिक्टेड टू रेलेवेंट फैक्ट्स ओनली।
Yes, sir, though it is not required, sir, but in practical scenario, sir, what I have seen, sir, the the environment starts to get a little tense if you start asking here and there questions, and in that the whole proceedings of the case are also get affected, and whole the courtroom also get
नहीं,
little
बट
disturbed.
if the objective of asking irrelevant questions is to shake the
Yes, sir.
credit of witness, then you are allowed to ask that.
Yes, sir.
So why the
Yeah.
environment will not be favorable? Law allows you. So
Yes, sir.
even if
Law
the
allows.
opposite party is raising the objection, even if the opposite party is raising the objection, even then also you can
Yes, sir.
ask,
Yes, sir. We can ask it, sir.
right? So the law
Yes, sir.
provides, na, in section 153 evidence it is written
Yes, sir. Yes,
that
sir.
if you want to shake the
She
credit of
can.
the
She
witness,
can. Yes, sir.
फिर तो पूछ सकते हो। तो फिर आप फिर सामने वाले वकील ने अगर आपको ऑब्जेक्शन लगा दिया, आप
Yes,
प्रोसिक्यूटर हो, आप कोई इरेलीवेंट सवाल पूछ रहे हो, आपका ऑब्जेक्टिव है विटनेस की क्रेडिबिलिटी शेक करना, डिफेंस काउंसिल
yes,
ने
sir.
ऑब्जेक्शन लगाया, तो आप डरोगे थोड़ी?
No, sir.
यू शुड गो फर्दर, है ना, एंड यू मस्ट मेंशन
Yes,
द
sir.
लॉ, है
Yes.
ना? ठीक। तो लेट सपोज तीन एक्यूज लोग हैं,
Yes, sir.
ठीक है। अब तीन एक्यूज में से वन इज द मेन ऑफेंडर, अदर टू आर द accomplice, है ना?
Yes, sir.
तो पार्डन ग्रांट किस व्यक्ति को करेंगे?
Sir, the one who is willing, firstly, he has to be willingly himself come forward and state that he is going to aid in the investigation. So that is, and जो जिन्होंने the person who has a lesser active role in the participation of crime, he will be given the pardon, sir.
तो मान लो कि कोर्ट ने पार्डन ग्रांट कर दिया, बट दैट
Yes,
पर्सन
sir.
इज नॉट रिवीलिंग ट्रुथ बिफोर द कोर्ट,
Yes, sir.
देन क्या कार्रवाई कैसे चलेगी आगे?
So the pardon granted can be always cancelled and he can be tried
नहीं, उसमें
as
पब्लिक प्रोसिक्यूटर का रोल बताओ मुझे यार।
my role.
यस।
My role is to, if he's not convincing and he's not trying to aid in the investigation, my role is firstly to tell him out about the all the consequences which he might face, despite giving the statement in the court that he will be aiding in the investigation. So that will be first step. If he still does not comply, then necessary representation can always be made into the court, and court can always take the necessary steps.
तो ये लिखा है कहीं पे प्रोसीजर में कि पब्लिक प्रोसिक्यूटर जो है वो एप्लीकेशन लगाएगा कि दिस
No,
पर्सन
sir.
इज नॉट रिवीलिंग ट्रुथ इन द कोर्ट?
ऐसा specifically I have not read, but
सेक्शन
I have
308 पढ़ा है
seen,
आपने? सीआरपीसी का 308।
sir, definitely, but I'm not able to recall, sir.
चलिए, द कोर्ट गिव्स नोटिस टू अ पब्लिक प्रोसिक्यूटर एंड लेट्स सपोज यू आर अ पब्लिक प्रोसिक्यूटर। तो उस प्ली बार्गेनिंग
Yes.
की एप्लीकेशन को आप कैसे काउंटर करोगे, कैसे रिप्लाई दोगे उसका?
So, firstly, I will see that it does not fall in the category where plea bargaining is disallowed, whether the application is maintainable or not.
हम्म।
So that will be the first, and then, sir, I will see the conduct of the accused. What if there exist chance to allow him to go and use this remedy. And then
Hmm.
I will also have to consult the victim, what they say and what is their approach and what they are thinking. So based on these facts, I will draft my replies.
ठीक. Okay, my last few questions to you, Aditya. Just
Yes.
tell me that why I should select you.
Yes, sir. Sir, I remain flexible, sir. I'm open to learning. I always am open to learning. I want to work hard, sir. Then, sir, especially as my academic background, it has helped me to gain necessary research skills, sir, and drafting skills. Because I have predominantly drafted at every day for the last 2 to 2.5 years, sir. Then, sir, also I am open to learn new things, sir. I can be molded. I am young, so I can do whatever is needed to be done by me.
Good. Good.